Hey everyone, welcome to another episode of the Ask Amity Show. And today we want to talk about joint ownership and whether or not it's the right way to plan. So many of our clients tell us that someone else is on their bank account. We usually need to ask them to clarify what that means. Is a person just an authorized signer with no right to the money? Or is this person a joint owner with the right to withdraw all the money now and half of it after they die?
So most people don't really know or they're unsure about this. And we need clarification usually from the bank or from other people in their lives. So once we do get these questions clarified, then we discuss their wishes and determine whether or not this joint ownership with right of survivorship really is what they want. So some scenarios that may occur, for instance, oftentimes clients may want a spouse in a long-term marriage to be on the bank account with jointly, right? So that means they have a right of survivorship. But what if things have changed with the marriage and the relationship has gone sour? Or if after they suffer a terrible accident or disease, maybe the spouse decides to protect himself or herself by getting out. People's intentions do change.
Another scenario is people will oftentimes hold a bank account jointly with a child and trust that that child will split the money with siblings after they are gone. So this is something that clients often tell us they do because it's just simpler, the child that has been designated as a joint owner. But oftentimes the intended result doesn't necessarily happen. If your child is, for example, in an accident or their marriage is facing a divorce, or maybe they have some personal liabilities due to declining business, do you want to risk the possibility of your money going to pay their debts?
Another scenario is about second marriages. So second marriages do pose another risk. When one spouse becomes ill, their child acting under a power of attorney can drain the bank account for their care, or the spouse's child acting under a power of attorney from their parent can also drain the account to prevent their parents' funds from being used.
So to avoid some of these potential risks, it may make more sense to have these accounts in a revocable living trust and naming a successor trustee to manage these accounts. You may also want to set up a durable power of attorney to appoint an agent that can access the money in the event that you become incapacitated. If you want money in the account to pass outside of probate and to be immediately available upon your passing, for example, to pay for final expenses, you can name a beneficiary on the account via a payable on death. That's all that we have for you today. Thank you for watching. If you have any questions about estate planning or joint ownership of your accounts and your personal assets, give us a call. We'll be more than happy to discuss. Otherwise, please like and follow our channel.